Feminist Legal Perspectives, Equality, Care, and Vulnerability. Thank you all for taking time out and being here tonight. We thank especially Serena for being here with us tonight, and Taís for having accepted the challenging but edifying, I think, task of commenting and giving initial feedback on Serena's paper. So, grazie Serena e obrigado Taís. This is an international event in a sort. Well, okay, Anna.
Okay, I'd like to thank you, Serena and Taís, for Serena for accepting the challenge to discuss it with us, discuss your paper with us, and Taís for commenting on the paper. And okay, I'll read the both. So I don't forget the qualifications. Okay, Serena is PhD in political science in University of Pisa, and is a researcher in Research Center on Discrimination and Vulnerability in University of Modena. And Taís is PhD candidate in FGV São Paulo and obtained her master in the same university. I'm very nervous, and I apologize for my English. And okay, Pedro, if you like to continue. Oh, and I like to note also the presence of Professor Dimitri Dimoulis. Thank you also for being here and discussing the paper too. Okay.
Okay, so just a brief note on the dynamics of the discussion of the event. Serena will have about, I don't know, 10 minutes to make a brief introduction of her work, mainly to contextualize how she came up with her ideas or explain which kind of comments would be helpful at this stage of her work. She could take the opportunity to clarify a first question related to the scope of the paper, whether it is part of a larger book or project, or whether it is an autonomous article, for instance. But then I will give Taís, we don't have a floor, but I will give Taís the floor for comments and feedback on the paper, to which Serena will have the opportunity to reply. And afterwards, we will be collecting comments and questions from the audience in series of 2 or 3 questions at a time. Well, I think without further ado, Serena, the floor is yours.
Thank you very much. And first of all, really, I would like to thank all of you for this wonderful opportunity to discuss my paper. Thank you in particular to Pedro and Anna and Michele and Taís for the organization of this seminar. I'm really grateful and happy to receive your critiques and comments that will certainly improve my work. Just a few words about me. I'm a researcher in philosophy of law at the University of Modena and Reggio Emilia in Italy. My research area is mainly the history of philosophy of law. I worked on Mary Wollstonecraft and Edmund Burke, but I'm also the coordinator of the research activities of the already mentioned Interdepartmental Research Center on Discrimination and Vulnerabilities in Modena, and I managed many different projects about discrimination law and gender equality in the contemporary debate, as well as in the last months about technology, equality, and the law. Well, this paper has been published as a working paper in a collective book realized within the European Jean Monnet module European Law and Gender, coordinated by Professor Elettra Stradella at the University of Pisa. As you already read, the paper focuses on Catherine McKinnon, Joan Tronto, and Judith Butler's different feminist legal perspectives on equality, care, and vulnerability. I know, of course, that at least 2 of these 3 authors are not properly philosophers of law. Tronto is a political thinker and Butler is a philosopher, but I tried to focus on the aspects of their thoughts that are relevant for the relationship between law, sex, and gender. Well, in these very months, in my country, Italy, this nexus between law, sex, and gender has been brought to the attention of the parliament and the public debate, in particular with reference to a law proposal regarding gender violence and homotransphobia that has been translated into a debate on gender identity and its possible self-assessment. This confusing debate made clear at least that some feminist groups are still leading a long-standing battle against the normative power of gender and its stereotypes, while other feminist or trans-feminist groups are instead reclaiming gender as a part of their identity. The debate on sex and gender is therefore at stake again. In my understanding, McKinnon defines human beings as sexed beings, since the original distinction among humans depends on the biological fact that some of them are physically exposed to rape and sexual assaults, while others can physically rape, therefore they do it. This physical distinction is the premise of the sexual difference and of its political relevance in our societies and legal orders. McKinnon's proposal aims at refounding law, thus subverting the distinction among those who have power and those who don't. As I state in my critical objections, I'm not sure that changing law is a sufficient tool to subvert not only the legal, social, and cultural dimension of the sexual difference, we can call it the gender dimension, but also its biological premise in McKinnon's terms. It has the physical exposure to sexual assault. On the other hand, Tronto's universalization of the ethics of care is grounded on a sentimental, moral subject who is not sexed at all. This view encourages a perspective that has been widely claimed in Italy in the last months during the pandemic. Care has been claimed as a political priority, strictly associated to the further development of democracy, equality, social and familial justice. As I stated in the text, in my view, the major weakness of this perspective lies in the shift from ethics to law. If McKinnon trusts too much the power of law, Tronto leaves law completely aside, and she finally came back to an idea of universality, which is the very starting point of the feminist critics since their historical origins. Lastly, Butler's view of a relational subject that creates him or herself at the intersection between bodies, performative actions, relations, alliances, and mutual recognitions led some scholars to a further reflection on vulnerability as a new linguistic and legal tool. I already explained in the paper that the concrete advantages that this tool can bring are quite limited. Moreover, Butler's reflection blurs the line between the sex that we are, sex is here just opposed to gender as the repetition of a series of performances, and the sex that we have with others. I mean sex as a sexual orientation and sexual preferences. the idea that the subject can really regulate and self-assess his or her gender membership is also much disputed and controversial, as I said before. My aim in the paper was that of presenting 3 different perspectives on sex, gender, and the law, in order to show the intrinsic pluralism of the feminist legal studies was different articulations and understandings sometimes appear even as incompatible. I, however, believe that reflecting and discussing on the concepts is always enriching. And well, this is the reason why now I'm very happy to leave the floor to you. Thank you very much once again.
Thank you, Professor Serena. Now, Pedro, do you want to? Okay. Now, Taís, if you want to begin your comments, take as much time as you want. And thank you again.
Hi, everyone. Good evening. Do you hear me well? Everything's fine? First, I would like to apologize because my dog barks a lot. So if a dog starts barking, I am so sorry. She's uncontrollable. It's impossible. I've tried, but that's, well, that's something. So thank you very much for inviting me. Before we were talking Portuguese, but so Professor Serena and the Italian colleagues can understand. I was thanking them for that. It's a great opportunity to come here and meet the group and meet Professor Serena. So I'm really honored with the invitation. And really nice to meet you, Professor Serena. It was really great to read your paper. At first, I would like to say that you chose such a hot topic, like, because I've been to Law and Societies Congress recently, and they had like maybe 5 panels on vulnerability. So that's something that it's really, really on right now. And I think that COVID brought everything, made it even more important now, because we think about care work, about caring about other people, about not only in interpersonal relationships, but also as society and universe as a whole. So it's really nice. And they have talked about COVID and also vulnerabilities and care in scholarship, which I find super interesting. So that was a first comment. I have some comments. The first one is that it's clear that you are a legal philosopher by the way you write, because I mean, it's very, it floats really well. You make your arguments really clear. So, I mean, for me, it was a pleasure to read it. At the same time, you write like you're more direct than other feminist authors that are really sometimes confusing, such as Judith Butler. Myself, I find quite hard to read, and your work instead is really easy to follow and to understand. So I will start some comments I have, but I do apologize if I have understood anything wrongly, because it's terrible when someone is invited to comment and then the person misreads completely and the comments are not valuable. So I am so sorry if that happens, and that would be completely my fault. Just so I can make a first statement. So in your paper, you aim to present an overview of some attempts to create new representations of female subjectivity, important to reflect on its essential categories to the study of women and the law, such as equality, care, and vulnerability. More specifically, you are interested in the works of Catherine McKinnon, Joan Tronto, and Judith Butler. First, I have some general points, which is, I think it would be interesting to understand what you mean when you're talking about representations of female subjectivity. Because that's, subjectivity is a very open concept. So I think it would be interesting to understand what you mean by that in your paper. And then another point is that it would be interesting to know why you have chosen to discuss the authors you have discussed. And I ask that because some other authors, like for instance, Frances Olsen and McKinnon herself, would disagree that McKinnon's theory is interested in subjectivity. In Olsen's words, and then I'm quoting from a text called Feminist Theory in Grand Style, McKinnon's emphasis is less on the process of how women make meaning in their lives and more understanding the structure of gender domination in order to devise effective strategies to eliminate the subordination of women. So here we can see a focus more on structures than on how subjects are created and feel about themselves. And I think that says a lot about how lacking in ethics and moral considerations her work is. It doesn't mean that, of course, that you cannot have a different reading from Frances Olsen, for instance, but maybe you could address this point because the choice might not be obvious to some readers. Or this could also be solved by explaining what you mean by subjectivity and telling how McKinnon's work, for instance, fits in your analysis. So the last general point is that sometimes it is unclear if you're describing the different branches of thought or if you're making a normative argument about them. This is particularly present in the turn from McKinnon's work to the other perspectives, because I got the impression, and that might be wrong, maybe it's something about the language or about how you structured the paper, but that you seem to have a preference for the last authors that you present. And I don't know if that impression is correct or if it's something that it's I don't know, in the language, as I said. So in view of that, it would be interesting to know which perspective, either descriptive or normative, you adopt and what context is the chapter inserted, meaning where are you going from this chapter? Now you said that it's a chapter in a collective book, so first I thought that maybe you would be writing more, developing more your ideas, which I think it's super a nice idea if you want, because I think the paper has a lot of ideas that could be more developed in other papers. So it would be really interesting to know your thoughts more. But I don't know if you have already done that. So that would be interesting to know what this paper means to you. Where are you getting? What are you getting from it? So, and also, if you're indeed advancing an argument, it would be interesting to know from the beginning what the argument is. For instance, do you believe that McKinnon's work is less able to provide good grounds for real transformation than the other views you address because of the paradox of essentialization / dominion perpetuation potential you identify in her work? Because it seems to me that what the other authors offer to you is precisely the grounds of, okay, so when we reach equality, what does it look like? Equality, this ethical transformation would be deeper and more radical than just a legal one. So it would be interesting to understand if you are trying to argue something, make an argument about the authors. It would be interesting to know that from the beginning. I have some points specifically. I have to say before anything that I am perhaps the biggest fan that ever existed of McKinnon's work. So I studied her work in my master's. Last year, we invited her to FGV to talk to us virtually. I correspond with her frequently because I really like her work. So whenever I am in a discussion, I am always saying I will be her lawyer. So I'm always her lawyer, which doesn't mean that I know all the critics and agree with many of them, but I think it's interesting to when we point out some critics and other person comes, and in Brazil we say devil's lawyer. So a devil lawyer is when you're really trying to defend a point. So that's what I'm going to do. Okay, so first there is a minor point that is, you describe really well, from my perspective, McKinnon's stand on equality, which is not common. I mean, you have a lot of people that misunderstand what she's doing, and you got it precisely. But then there is one phrase that I think that misses the point that you had just defended when you said, to this extent, McKinnon's view of substantive inequality unequivocally focus on discrimination, an unjustified or disproportionate treatment or disadvantage depending on the membership to a certain oppressive group, rather than on sameness and differences. Okay, she's of course critical of sameness and differences, but I don't think she's really interested in justified or unjustified, because for her, justifications may exist in the concrete reality, but that nonetheless, that shouldn't limit our search for equality. So she's really critical of this need for search which treatment in a certain way is justified or not. So that's just a minor point. A second point, which is more general about that, is that it is not clear exactly if, when you state that some critical objections should be formulated, if you're just presenting those objections without adhering to them, or if they are objections you adhere to. And if the second is the case, I have some considerations I would like to share on the objections you have pointed out. So you say that the acumen of some argumentative approach able to conceal possible inconsistencies, for example, the semantic shift between differences and inequalities, or between sameness and equality, or even between politics and power, is not always clear. For me, as a person that has read a lot of her work, the conceptual differences are very clear. So differences mean differences, and inequality means subordination. And this is something that becomes clear when one reads the ensemble of her work. So if you disagree with that, or you want to develop this objection, it would be interesting to show the reader examples of when this confusion appears, and more importantly, what their consequences for the intelligibility of the arguments are. The second objection is that you state that the Homo mulieris lupus, I hope I have pronounced that correctly, remained controversial, hypothesizing the conflict between men and women, while at the same time presuming the possibility of a universal community of militant sisters appears to be quite problematic. This bifurcation could lay itself open to essentialist drifts on the diverse nature of genders. Otherwise, the dominion logic become insidious. When women have power, will they, by nature, subjugate other social groups? So this argument of yours is very complex and powerful, and I have never heard it before, which is interesting because I'm always, when you work with McKinnon's work, you read more critics than her actual work, and this one was a new one for me, and it's really complex. So I will be reading the thoughts that I have that came to me. Okay, if I understood it correctly, she incurs in a kind of paradox. Either she assumes that once the community of sisters get power, they would lead to a better world because of their nature in comparison to male nature that is driven to domination, or that once women get the power, they would do just like men and dominate others. I think that this reading perhaps gives too much focus on subjective aspects, and in a previous passage you referred to instinct, for instance, that are not at all important to McKinnon. So McKinnon is not, she's not arguing the same level of authors that say that men are inherently bad and power corrupts them and they have an instinct or a drive to subordinate. I think she's more interested in structural issues, not the human nature in any aspect. So if my reading is correct, I think that the critique you pose is not applicable to her work. She's saying that union, which I understand as consciousness rising, which is something very important in her work, is her method, would unmask subordinating structures for women. So she's not attributing a nature to women and men. At the same time, as she's working with radical changes, that is, rupture with structures, she's not incurring any necessary argument that power leads necessarily to instinctive drive to domination. I don't know if that makes sense, but it was a preliminary thought on that objection you posed, because it was a first for me, so maybe my thought is completely wrong. And the third critique, I believe to be the classic one of universalization and intersectionality. And in this sense, I think it's important to notice that this is something of in this point, this is something like a boogeyman from my perspective. McKinnon's radical theory of law is twofold. Her first work focuses on substantive theory of the state, in which she states that the core of women's subordination is the alienation of sexuality. Just like in Marxism, it would be the alienation of work. So this stance of her work has been thoroughly criticized, rightfully in my view, by authors like Patricia Kane talking about lesbian women and by Angela Harris talking about Black women. But McKinnon's work, however, has a second stance, that is her method and what she understands as being the problem. So if used correctly, the method, which is to look at the concrete and then think about the laws and structures, etc. So if the method is used correctly, which she herself does not when talking about the substance of oppression, but when used correctly, it leads to the elucidation of power relations that play a role in legal doctrines. This is what she does in the equality discussion that is central to your paper. So by using her method, that is, thinking from the bottom up, she criticizes the Aristotelic approach and comes up with an anti-subordination approach. This equality debate, which is one, this equality debate is not subject to the criticism of lack of intersectional considerations, as it is indeed constructed from the bottom up with no universal intentions and therefore inherently intersectional. Proof of that is that Kimberly Crenshaw adheres to McKinnon's criticism of the Aristotelic approach. And I don't like to use that as an argument because I think it's a weak one, but Crenshaw is the only author besides Andrea Dworkin that has paired up with McKinnon in recent writings. So in sum, I believe that this criticism is one, not applicable to her equality argument. As for her, equality is more of an substantive equality is more of an analytical tool or reflection framework than a substantive argument about men and women in abstract, and in no way limited to men and women in abstract. And two, actually in her recent work, she started to work with the category like white, upper class, male, so she started to incorporate other like intersectionalities. I don't know, but she has done that. So secondly, I think it's unfair to her writings after the intersectional criticism she has received to not recognize it, how her work has incorporated those criticisms since then. So also the subject of rights, if grasped correctly, which once again is not in her theory of the state, is not men or women, but rather intersectional subjects. Although from my perspective, she's not interested in subjects, but rather in structures. So in this sense, I believe that Bourdieu's point cannot be contraposed to her, and she's radical enough in what she envisions as equality, albeit not enough as she uses the law. So she is interested in the law, but not only. I think she believes that the law can be a tool to modification, with other more radical feminists think it's not the case, but I think that in no way she is limited to the law. but I agree with you that she doesn't have an ethical or moral stance about equality. So finally, I don't think she's interested in thinking. No, I think she's. Okay, so finally, I don't think I think she's interested in thinking about structural ruptures, not about grasping power. Instead, she's interested in getting away with the domination structures, not reversing them. So by the end of the day, I don't think that the paradox that her work would maybe necessarily lead to women getting the power and then having a drive to dominate others. I don't think that's, I don't see that in her work. So in any event, if you're just describing the objections without adhering to them, it would also be interesting to let the reader know why you're posing these critics in particular, and not many others that have been directed at her work. And if so, it would be, I mean, it would also be interesting to know how these specific objections that you have chosen to present affect what you're arguing, because some other objections have been left out. So why those? And then I have other points, but I don't want to take much longer, but they're rather quick. So when you talk about sentimental subject and the ethics of care and vulnerability, it's, I mean, isn't the existence of a different voice, even if socially constructed, as deserving of, or even more deserving of intersectionality criticism as Makinon's theory? It might not be female, but it assumes a homogeneity that among the poorest and most oppressed groups that might not exist. So that's a criticism that comes from Janet Haley's book, How and Why to Take a Break from Feminism, which is a book I find appalling, but the criticism is there. I mean, I really don't like this book and her stance, and I don't like it, but the critics, the objection is there, and is if you're posing it to Makinon, I think it would be interesting to be posing to the other theories you are addressing as well. When we talk about the theories, another objection that comes is, aren't we, to some extent, romanticizing an ethics that arises out of oppression, and that might be good, but is still very oppressive in our work? But this is something collateral. The third one is, whereas in Makinon's work I see propositions for how we get to equality, that is, radical legal changes, I fail to see how can we achieve a society that values care and vulnerability. I mean, other than Butler's idea of disruptive individual performances, I cannot grasp concrete propositions on how we get there. And this is a common critics' objections to cultural, the so-called cultural feminism that is also laid out by Janet Haley in her book. But that wouldn't that be utopy? I don't know how to say that in English. Utopic, maybe. I mean, how can we go to the ethic or the better saying, the politics of care, and to a place, a world in which vulnerabilities are considered and valued, and become a way of thinking about the world that is a better ethical stance than what we live in today, and more so, Butler's idea has also been criticized for being individual. So, I mean, when we go there, aren't we risking like depoliticizing the issue? That I think that's something that really bothers me in her work. So also, I think it's a part of this point. Can vulnerability and care ethics theory be translated into jurisprudence as Makinon's? I think you addressed that in your initial statement. they are not Butter and Joan are not legal theorists, but McKinnon has a political theory of her own that can be translated into a jurisprudence or legal theory, like Ronald Dworkin's, for instance. He has a political theory and then he translates into jurisprudence, while I fail to see how a political theory of care, of the ethics of care and vulnerability can also translate into legal arguments. And then in the part of vulnerability and the law, I fail to see how the previous discussion on care and vulnerability is actually related to it. It seems to me that well, in fact, when I read vulnerability in the examples you give, they could as well, from my perspective, be understood as subordination in McKinnon's sense, more than vulnerability in the sense you have discussed previously. So that is powerless beings. So vulnerability in the law seems to me to be related to social hierarchies and the positions that people occupy in hierarchical societies, rather than their relations to other people. So yes, that's it. And as a final consideration, it would be nice to know what you make of your exposition as a whole, like connections between the authors, departures, through proximities. One interesting discussion is about the fact that whilst McKinnon provides the legal means to fight, some authors argue that she doesn't really know where she's going. What would be then a good world besides a world that doesn't have pornography, for instance? What else would that be? And it seems that cultural feminists have a lot of that, so they have a lot of good insights of what a good ethics would be. So it seems to me that they're complementing each other, and that's something that becomes apparent in your work. So I think you could perhaps develop it on that, like in the sense that they are not contrasting but overlapping. And yes, that's just something to think about. I'm sorry if I read a lot, but as your arguments were really powerful, and I thought it was better to write down and think about it rather than start saying and then like, oh, I'm sorry, I don't know if I made myself clear. But thank you very much. It was a pleasure to read your paper, and I'm looking forward to read more of your work. And my biggest suggestion is for you to keep going on that and developing more, because I really want to hear what else you have to say. So thank you so much.
Well, thank you, Taís. Those were really valuable comments, I think. Serena, you don't need to reply to all of them, but you can react to some of them before we collect comments from the audience. But before that, just a message to the audience. For those that for some reason cannot formulate their questions in English, Serena also understands Spanish, I think. Am I right, Serena? Yeah, okay, yes. So you can ask the questions in Spanish. Or you can write down the comments in the chat and we try to translate them to Serena. So, Serena.
Thank you. Thank you very much, Taís, for all your comments and your very accurate and precise reading of my text. And thank you very much for the points that you focused on and you stressed. I really can't answer to all of your comments, really, because in some cases I have to think about them. They are very, very enriching and useful, so thank you. And however, I will try to reply by giving a sort of general answer to your comments. But really, thank you very much, and I will be happy to keep in touch and to have a further conversation about these topics. Thank you very much. Well, first of all, I started to work on this paper starting from the three keywords, equality, care, and vulnerability. And I immediately associated to each of these words an author that I thought it was relevant in order to, well, to say something according to a feminist legal perspective on these issues. And this is the methodology that I chose because this work was associated to other papers that were discussed during some seminars and then collected in this text, which is, however, an ongoing work because it is still a sort of collection of working papers, as I said. So we are still reasoning on these issues, and this is a very good experience that we are having because this is a Jean Monnet module. Therefore, it is a project that gave us the opportunity to organize many discussing seminars and events and situations in which we came back on the same topics. And so this is also the reason why these are like first hints and first reflections that are conceived as thoughts that should be further developed. So I know it is quite it's weird a little bit as an approach, but this is also the reason why your comments are so useful for me. I try to answer starting with the observations that you made on my own critical observation to McKinnon. Well, first of all, the part on McKinnon is the one that is the part I focused more because probably because I took it seriously, particularly seriously, because I believe that it is full of very interesting ideas. So differently from what you said, I prefer, or well, I'm much involved in this kind of reflection because of the consequences on sex and gender and law, as I'm trying to explain a little bit further. So first of all, I said that McKinnon sometimes uses words such as sameness or identity or equality or politics and power in a way which is not always clear, because sometimes she sometimes wants to give strength to her own arguments, but I'm here referring to critics that has been moved by an Italian author, an Italian scholar, which is quite known within the Italian context, which is the criticism formulated by Letizia Gianformaggio, that read McKinnon works in a very analytical way, and particularly, and Gianformaggio particularly focused on the idea that equality and difference are not incompatible at all, and equality postulates differences, and this is something that sometimes in McKinnon's reasoning is well, not misunderstood, but it is used in an assertive way in order to, well, give strength to her arguments. But I think that it could be explained in more accurate terms. And once again, here I had in mind some pages of Gian Formaggio's works that were, in a nutshell, that were a criticism against the same idea of the difference dilemma, as formulated by Martha Minow or John Scott and so on. Because equality does not mean identity. It means that equality is a relative concept among different entities. So this is the reason why it postulates a kind of equality, because it should be referred to a relevant characteristic. And this is also the reason why Gian Formaggio distinguishes three different kinds of three different dimensions of equality: the descriptive, the normative, and the evaluative dimensions. The descriptive and the normative, I mean the idea that A is equal to B according to a relevant characteristic, and the idea that A should be treated, ought to be treated as B because of normative grounds. Well, these are not inherently related to that power dimension, which is instead the characteristic of the third view of equality as a kind of evaluative tool, and it is referred to a collective and structural dimension as well. So this is the part that McKinnon emphasizes, and it is the part that McKinnon focuses on. In this sense, if we agree on the fact that equality can be used as a evaluative tool, so if I say that A is different from B, I want to say that B has something, as a kind of inferiority, because he is not like A. And in this sense, there is a deep connection with the structures, as Taís said, and as McKinnon also said in her works. And even in this sense, even the equality rule, or as Crenshaw stressed, even the non-discrimination tools can be marked by these structural dimension that permeates law and legal tools as well. And even the way the equality principle or other legal tools are created and formulated can be favorable to social hierarchies. So here the problem is thus to refound law with new tools, but not abandoning law as a lever to change reality, as McKinnon said. Even if, and here is another point that I think can be that Butler has highlighted in a very good way. Social hierarchies and norms aren't produced only by law. There are other sources of normative power that came from social practices and social relations. And we can think at Foucault analysis on microphysics of power and the distinction among the political and the juridical sources of power. And in this sense, this is something that I think McKinnon doesn't grasp, this idea that there is something else that is another source of normative power, and therefore law can do something, but there are also other social dimensions and cultural dimensions behind. And however, the point that McKinnon grasps in a very good way is the collective perspective which is needed in order to focus and to act and to fight against these structural elements of reality. And as Taís said, Wagner's view, and I also said it in the paper, I think, is an individual perspective, a critical and individual perspective. And it is not a case that Antigone is claimed as a kind of symbol. Antigone's effort is an individual effort. And here is another problematic view, because it can lead to a false friend or to an ambiguity which is typical of the contemporary discussion and the much updated works on these topics, which is the debate that considers the neoliberalism and the other elements that are creating social structures, for example, also with reference to the economic dimensions of reality. And I think this is another interesting element that should be or could be emphasized. The idea that this neoliberal individualistic approach presents an idea of freedom that is explained in contractual terms. It is the choice of feminism or the post-feminism, but it is an apparent freedom because, and here I come to the point when you said you focused on discrimination and you associated discrimination and McKinnon. Why? The point is that discrimination, as in particular indirect discrimination in the European lexicon, is conceived as something that happens to oppressed groups. And once again, here we have the need to use these categories that lead to collective dimensions and to pose the problem in these terms, in these collective terms. And for example, I think it is extremely useful, it is still useful, the reflection formulated by Iris Marion Young about the 5 phases of oppression, because it focuses on the external elements. So there are some external conditions that are beyond the subject and the choice or the apparent free choice that the subject can do. Exploitation, marginalization, powerlessness, cultural dominance, and violence. So these are objective criteria to look at the condition of groups, of oppressed groups. When I tried to look at the thoughts of these 3 authors, asking to myself which is the idea of female subjectivity that these authors presented. And this is the reason why I started with this sentence, this statement on subjectivity and on the fact that these views postulates, in McKinnon's particular case, or aims at a particular view of the female subjectivity that is created by practices and theories and jurisprudence as well. And in particular, with reference to McKinnon, I think that there is a theoretical background, because if we read, and we did it, her first works, and not only the works written after the the 2000 when she focused much more on the case law and the jurisprudence. But the first works, starting with the 1979 and then the 80s and the 90s publications, had a theoretical background that I think is the basis of the theory that she develops in her case law analysis. And I was interested in that because I found, or I think that there are some, well, inconsistencies, probably because she didn't care much on that part of her theoretical reflections, because she has another aim. Mainly, she's a lawyer and she wants to focus on the law dimensions and the jurisprudence, because it is useful in order to change reality, because of the symbolic function of law that can change things, that change social behaviors. And so this is the explicitly her aim. But I was, however, interested in the theoretical idea that she had in mind. And I found that she often quoted Susan Brown Miller, for example. And here I found that connection when I quoted Thomas Hobbes' State of Nature. It was obviously a metaphor, but I said in the paper that in the state of nature, in McKinnon's State of Nature, there is a war of everybody against everybody, but it is a sexual war. And I think it is useful in order to understand her view, because this is the premise, and this original condition, the fact that some humans can rape before they do it. Well, it is the starting point of all our analysis, and it is something that we cannot escape. In this sense, I came back on this premise during my own descriptive presentation of her view, and also in the part where I criticize some aspects of her thought. And then there is the part on care, but I think that it poses, well, it focuses on an issue which is not considered by McKinnon, which is the issue of dependency. And this is another interesting situation, because through the analysis of another author and another issue, care, John Tronto, and another debate which is focused on ethics, I can add in my text, I can argue that McKinnon's view of humans is a collective view, but it is a collectivity made by individuals that are not linked by those dependency relations that characterize instead the individuals and the subjects that are defined by Tronto. So it is a different view of subjectivity in these terms, because different ideas of humans are postulated. And then the third part about Butler and the vulnerability term, the so-called vulnerability term. In Italy, in the last years, many philosophers of law have studied the vulnerability theories, and it was also part of a huge project that was founded by the government, the Italian government, on this topic. And in the end, in the paper, I tried to collect some of the well, the outputs of this big, huge debate, which is an international debate, but it's been discussed in Italy as well. And I was interested in the way vulnerability recently entered the legal domain. And it entered the legal domain as a kind of alternative, or a potential alternative, a possible alternative to the equality principle and the consolidated tools and legal tools. And it has been studied in heuristic terms as a possible new tool that could say something more. And in this sense, it was an attempt to create new legal categories and new legal terms in order to, well, once again, conciliate equality and difference, and to find some ways to represent the peculiarities of the female condition, but at the same time giving it a universal dimension, or a recognition within the legal tools. And I said in the paper that I'm not sure that the outputs that have been produced by these legal tools are satisfying, are completely satisfying, because it leads to a foundation of the universality of rights, but I think it does not add something to the legal background that we already know. And it was really a statement that has been reached by many scholars that studied the vulnerability term, and in the end concluded that, well, it is a problematic and complicated expression, and probably it is not convincing, or not completely convincing. And in the end, I just conclude mentioning the three moments that Carol Smart quoted when she said that, first of all, we should understand that law is sexist, and so we should change the discrimination that are evident and are present, the distortions and the different treatments that were established by the law, and for a long time have been established by the legal structures. But then we should also focus on the idea that law is male, and therefore the standards and the values are based on a subject of rights that is based on idea of a subject of enunciation, which is a male. And there is also a third phase, a third stage, which is the idea that law is gendered, and it means that law shapes subjects, create subjectivities, and create gender, and create our definition of gender relations. And well, I think there is much to do, but and I don't have answers in this sense, but each of these three different perspectives says something which can be useful. And finally, that was my simply my my aim, just to well, generate comments and discussion. So thank you once again for your time, your availability, and for this opportunity once again.
Thank you, Serena. Taís, do you wish to respond to Serena's comments, or should we collect some questions? We have 2 hands raised, but as you wish.
I think you could collect questions so Serena can have more comments, and in the end, if there's time, I can jump in and ask another question, but let people.
Okay, then, thank you. I think Danielle and then Natasha.
Okay, thank you very much, Serena, for your very engaging work, and thank you, Taís, for the illuminated thoughts. I did take a lot of notes here, and I'll be happy to share with you afterwards, but I do have only 3 very brief points here. The first one, actually, I wanted to emphasize, I think you already commented on it, you don't have to bother to talk about it again, but I thought that although you did mobilize in a very interesting way theoretical perspectives to attack this pretended neutrality of so-called idea of subject of rights, it was not entirely clear to me if your argument was that we should choose one of these very different perspectives to move forward in thinking about rights, or whether we should think about an ideal solution that resides somewhere in between the ideas of text, sentimental, and relational subject. I do not think that the text made that your position clear in this respect. Second of all, I wanted, if you wish, if you mind, to elaborate on what do you think are the implications of your theoretical argument for the design of judicial institutions. Do you think that in making the case for women judges, for instance, is your argument sufficient to avoid the essentialist trap that entails that misleading correlation women feminist that Rosalind Dixon talked about in her work? Do you think that McKinnon, for instance, her perspective is sufficient to surpass this trap? And third of all, I'd like to think to ask you if you think that your argument about neutrality of subject of rights could be mobilized to the reconceptualization of another very difficult idea in law, which is impartiality in adjudication. How do you think that these 2 ideas can be correlated, and if you think that we can work with the same authors to debunk this also mythical idea of impartiality in adjudication? Thank you.
Thank you, Danielle. I'll use my powers to jump in Danielle's question because mine was very similar. I'm sorry, Natasha, but I'll be quick. And with the disclaimer that this is not at all my field, so I don't know if my question makes sense, but I also had the impression that these 3 notions entail different implications and maybe different solutions. But my question was not if we had to choose one. I got the impression that maybe the idea was to conciliate the 3 views. And then my question would be, if we don't have to choose one of them, how can law embark all the 3 and conciliate them with a solution? I know that solutions are not really your goal here in this paper, but I also had this curiosity. Natasha, I'm sorry. Okay, now it's your turn.
It's okay, never mind. Hey, so good night, everyone. Thank you so much for organizing this debate, and thank you, Serena, to writing such an important perspective on feminist theory. I mean, you brought up together such important elements on this whole thing, this whole social phenomenon going on. You brought up the human as someone who has a subjectivity, who has a very social perspectives. What I mean is that you really mix together that our identity sometimes, or in the majority of the times, is related to the power structures that govern society. And law comes as some of these structures. So we can talk about the social coercions, I mean, how you should dress, but law comes as a more imperative power, especially when we can clearly see that when we go to the carceral system. It's very clearly how the gender questions takes effect there. I mean, how the body, the female sex as a biological sex here, I don't want to go too much in the gender views, but it demands certain vulnerability. It brings up some necessities that the law and the dominant structures in society don't match up. So reading your paper, and I would like to congratulate you on that, it's very clear how the vulnerability comes from a very collective social sense of identity. And it surprised me that by analyzing those three authors, you gave us a very great perspective on how we are an individual self, but society comes and then law comes. Law originates from humans and it goes back to humans, but how it comes back to humans. And this is how oppression comes. I don't know if I made myself clear, and I'm sorry if I made some kind of mistake. Again, this is not my main field, but thank you so much for the night.
So, thank you very much once again. Very, very interesting questions. I start from Daniel. Thank you. Neutrality, essentialist trap, and impartiality in adjudication. The idea that the subject of rights is well, the subject of rights which has been created by the positivization of rights and the historical processes of vindication of rights as well, is a male, has been much disputed and much studied in feminist literature, and it was a kind of starting point in my reflection. I believe it is extremely interesting if you want to discuss if law can be a feminist tool or not, because in Italy in particular there is a long-standing tradition of feminist groups that denies the opportunity and the relevance of law in order to foster the feminist liberation. And I didn't want to follow this kind of perspectives because I believe that law is a fundamental tool, and I would like to question whether it can be refounded in Kim's terms, and in which ways. It is also clear that the problem of the partiality of law is related to the problem of the partiality in adjudication, and in the applicability of the norms in concrete cases. And thank you for having mentioned this point, which is, for example, extremely relevant in McKinnon's analysis. Also because she works in a common law context where the application of law is deeply connected to the activities before the courts. The problem of essentialism, I think, cannot be solved, but it is a problem that we should mention and discuss, because I think it is related to the other questions, in the sense that Anna asked me if, Anna suggested that these three different perspectives can be in a way joined by some fil rouge that I tried to present, and I think that one of these is the relevance of the structures, and as Natasha pointed out, subjectivity is created by social structures, by norms, by the power of law, and the politics of law, and so on. And here, once again, is the problem of essentialism. Nature, or the dimensions that are outside, that are heteronormative aspects of our identity, may conflict with the self-assessment of the individual that wants to state his or her own subjectivity, identity, and so on. And I think this is one of the aspects that are now, in these very months, at stake in the public discussion, at least in my country. One radical solution could be that of saying that women does not exist, and women are created by patriarchy, and they are completely hetero. Women is a completely heteronormative category. I'm not sure that it is the final solution. I think it is, once again, I think these topics question aspects of the creation of subjectivities that depends on the social needs and the social instances. For example, the present debate in Italy is clearly posing new perspectives on old issues, and so it is a process that is subjected to historical indications and events. So I'm not sure that we can find a definitive solution to those problems, but probably this is not the aim of our analysis.
Thank you, Serena. We now have three more questions. So, Deborah, when you wish.
Thank you. First of all, thank you for organizing this event. Thank you, Serena. If I can say a few words in Italian, just to calm a little bit down. Mi sentirò molto più tranquilla se potessi parlare in italiano, ma penso che in inglese saprò spiegare un po' di più i miei argomenti, quindi lo farò in inglese. pensando più agli altri comunque, ma pure all'argomento perché lo leggo più in inglese, quindi sarò un po' più facile da dirlo. Quindi, I'm sorry for saying those words in Italian for those who cannot understand. It was just a little bit for calming down because I feel more comfortable in Italian rather than in English. So, starting my point. I study a bit more international law, so my question is more on your view from a philosophical point of view. So, studying gender from an international perspective comes from a critical international perspective. We can see that women, as you said, is a created object, but an object rather than a subject. So, from international point of view, you can say that the system kind of takes from women and gender, as you can say, gender or sex. It takes from this object, this subject view. It's not, how can I say? As an object, you don't have actions, you are imposed something. So I would like to ask from my readings of your paper, your view of the subject of it. When Taís asked, I thought of this object point of view. So I don't know if I explained it well, was just a bit more from this post position of object versus subject and a philosophical point of view, because you brought that on your text. So I don't know if it links with your work, but I'm just throwing the questions if it is possible. Thank you.
Thank you, Deborah. Mileni now, I think.
Hi, I'll try to make the question in English. I liked the text very much. The reading is very clear. I also had some questions about the philosophical standpoint you use, because I am more familiar with Black feminist thought, and the authors like Patricia Hill Collins, Angela Davis, and even Kimberly Crenshaw, Bell Hooks, their theories are more rooted in reality, historical analysis, sociological analysis, anthropological analysis. And I was a little confused about this philosophical analysis that doesn't have this kind of root. For example, Ed McKinnon's work, which I don't know, I was thinking, doesn't she use economic statistics? Doesn't she make an historical and sociological analysis? Because it seemed to me that she was only making a difference between men and women in a philosophical standpoint. And my question is there is really like this? And in the second author, I was thinking about the sentimental perspective, because you presented as a universal perspective, but it seemed to me that it was a essentialized feminine perspective that was universalized for everybody. Women usually tends to care. Care is important. Now, care is not a job just for women. Let's make it a job for everyone. But this is a kind of essentialization, isn't it? And the third aspect of the Butler's theory, I also think you presented very clearly, and it is very pleasant to read. It is very difficult to read some of these feminist philosophers, and this is very important, this job, to make it more accessible to people. I don't know. But at this final point, I was thinking about the remarks you make about grief. How important is the grief to mark the groups that are vulnerable? Because I think we are in a very particularly historical context, which this characteristic can be more developed. We have on racial discussions about how Black lives doesn't matter like white lives, and we have about this pandemic context, how poor people and Black people died more from coronavirus, and how the violence of the criminal justice system makes it almost impossible to grieve. Here in Brazil, we sense the same context that I think there is in America. Here we like to say that racism is not so strong and everything is not so dramatic, but the Black movements here say the same thing. So when I read your text, I was, but it's because it's my perspective and what I study, and not necessarily a fault in your text, but I was missing this sense of reality rooted on this other analysis. Not necessarily about race, but I was thinking, for example, about Nancy Fraser's Fortune of Feminism, how she describes the economic consequences of the job that women do in caring that are not paid for. And Angela Davis in Women, Race and Class, as she thinks of the job of the domestic workers who are usually Black women, and how it doesn't becomes a question for all society why some people are more directly linked to the domestic work than others. Anyway, just sharing thoughts, not necessarily critiques. I liked your text very much. I just got this impression that I was reading a classical somehow text on philosophy of law that relates only philosophical perspectives, the analysis of Kant, Aristotle, and the juridical consequences. And I think it could be more of these other remarks. I don't know, just a thought. Thank you. I'm sorry if I if I was confused a little.
Thank you, Milene. And your question gives the opportunity for Taís and Serena to join forces in defense of McKinnon. But I'll just, there's one more question of Natasha, and then we go to the reactions.
It's more of a comment, actually. It's just when you said that the idea of women, the identity is made from a hetero perspective. Is that pronounced okay? Hetero? Okay, it's made up from society. I think if we look out in nature, we get to see this very clearly. I mean, females are females because of hormones on certain periods and not because of their identity, not because of how they see each other, not because of what they can or cannot do. And it's just a comment. I would like our society to be more inclusive on this sense. Good night.
When you wish, Serena.
Okay, thank you again. With respect to this last comment, I agree. Nature itself should be interpreted, should be defined. Once again, we need this interpretation of reality, and this. Well, it could be extremely controversial, as everybody knows. With reference to what Milene said, I should say that, at first, McKinnon emphasizes the elements of the features of race and the elements of racism, and she focuses, even in the case law analysis, on these aspects. Also, Butler is one of those figures and those international academic stars that is often associated with specific social movements and Black Lives Matter, and discussion about the pandemic, the experience of grief itself was connected to the events of 11/21, and she is much inspired by historical events, facts, social movements. So she is deeply connected with reality, and therefore probably my paper excluded those aspects, because once again I tried to offer a reflection on the philosophical statement that are in the background of these theories. And probably this is an interesting, another interesting critic, and then this is another aspect I should seriously focus on in the further development of this work, because from your words I understand that there is something that should be explained further, in the sense that these authors dedicated much efforts on concrete aspects of reality and the concrete dimensions of women's lives. McKinnon herself, she uses statistics, and she believes that her methodology is a kind of empirical observation of reality. And she, for example, it's a famous fact that she investigates the concern of pornography by addressing many women that were employed in the pornographic industry, and she represented women in famous legal suits and in different circumstances. So she has a deep connection with real women's lives. But I also think, and she states it, that she believes that all women have something in common, which is the experience of subjugation. And this is something powerful in her thought. And it is a kind of global commonality that can be referred to all women. And finally, the idea of reification, and the idea that, in my perspective, women are treated as objects. I think it is a consequence of the perspective that I tried to discuss, which is the idea that there are structures and they have a power that is creating subjectivities, even if these authors give a voice and try to, and I already state it with reference to the previous comments, they try to create new representations thanks to their own effort to understand and interpret and to, in a way, confront these social structures, these normative reality. And this is a way, this is an interesting way. It is true that we are made, but it's through the acceptance and the interpretation of these structures that the processes of creation of subjectivities can rise. Once again, I don't have a conclusive thought, because it's not my own view is not conclusive at all. I don't want to arrive at a final statement on this.
Thank you.
Thank you very much.
Thank you.
Thank you, Serena. Taís, do you have further comments?
No, just I would like to thank, because in your response, Professor Serena, you gave me a lot of food for thought. So I'll probably mail you later, because I already thought about a lot of things. And thank you so much again for the opportunity.
Thank you to all of you. Thank you very much.
Unfortunately, we reached our time limit, but I just like to thank you all for being here and participating, especially Serena and Taís. It was an amazing debate. I learned a lot. Like I said, it's not my field, and I think there's no best way to end this semester of debates. So just really, I don't have enough thank yous to summarize my gratitude. It was really a wonderful event and a wonderful semester. I don't know, Pedro, if you have comments.
No, Anna, I'd like to thank Serena and Taís again for being here with us tonight. And maybe, Serena, you could pass us your email, because
Sure.
you know, we could send some comments via email for you.
Great, thank you.
Okay.
And this is probably our last webinar of the semester. So I'd just like to thank also everyone who has been in more of one event. So you make PósDebate happen, and thank you a lot for being here and for being in PósDebate's events throughout the semester. And We'll have the calendar for next semester in a couple weeks. We'll post in our page, and we hope you liked this debate, and we hope you enjoyed it, and we hope you come in the next debates too. And thank you again. That's it. I think I don't know how to end things. And online, it's weirder. So thank you.
Bye bye.
Bye bye.
Bye.
Good night. It was awesome.